Good afternoon, good evening, or good morning to you all. I'm delighted to welcome you to today's intriguing webinar, Your Next Lawsuit, coming from a river or forest near you. As we face climate catastrophes and mass extinction of plants and animals, non-human entities previously categorised as nature are being granted the status of legal persons. Such legal personality facilitates and enables bio-geo entities to sue in their own name, enforcing their rights and protecting their interests. These fascinating developments arise in the context of the courts recognising and enforcing greater understanding and responsibility for protecting the environment for future generations. This concept may seem very alien to some, but coming from New Zealand, I'm familiar with natural landmarks and geographical assets having rights and protections under law similar to human entities. And today I'm pleased to be joined by an expert in this field, Stewart Motha, Professor of Law at Birkbeck, University of London. Professor Motha served as Executive Dean of Birkbeck Law School from 2016 to 2022, and next year will take up the position of John Hinkley Visiting Chair at Johns Hopkins University. Congratulations, Stewart. He has published widely on issues associated with sovereignty, imperialism, and indigenous land rights, and is the founder and host of Countersign podcast, which we will share a link to in the chat box. He is currently working on concerns with the environment and resource extraction, and will shortly explain the implications of these legal developments on social and legal organisations. As always, before we begin, some brief housekeeping points. I'm Charlotte Dawber-Ashley and I manage the FS Club here at ZN. And I'd like to warmly acknowledge our very generous sponsors who enable us to continue to bring you a wide range of thought-provoking content across finance, technology, economics, and today, law. The slides for this presentation are publicly available on our website and in the chat box. The session will be recorded and available to watch on our website within 48 hours, and we'll be holding a 20-minute Q&A session after the presentation. So please use the GoToWebinar chat facility to send your questions in to me, and I will feed them into the conversation. Now the boring stuff is out of the way. I welcome you to take the virtual floor, Professor.
Thank you, Charlotte. I'm delighted to join you on FS Club and talk to you about the challenges that are emerging in the context of climate change. We are coincidentally speaking to each other at the beginning of COP27, which is taking place in Egypt. And there are many conversations underway about the sustainability of our current economic, social and political models. And some of the colleagues and friends joining us today might be asking themselves, well, what's the point of all of this discussion? Don't we have to do more than this? Or indeed, depending on your point of view, less than this, in the context of the challenges we're facing in relation to climate change. So what I want to talk about today are some of the legal developments that are going along in this context. In particular, the emergence of legal personhood being attributed to non-human entities such as rivers, mountains, trees, and non-human animals. The status of nature overall, how do we think about the status of nature? And that might be something that we can discuss further. A more traditional idea of legal standing, which is to say the capacity of an organization or an entity to come before the courts, which is ordinarily characterized as legal standing. How human rights are being deployed in the context of climate change, and there's several cases that I'd like to draw people's attention to. And finally, the emergence of a new international crime of ecocide. It hasn't yet entered into the books, as it were, of international law, but a draft crime of ecocide has been created by a panel of experts, and I would refer the audience to that. So they're the issues that I'm going to cover today. So we can move to the first slide now. So Lake Mary Jane is in Orange County, Florida, and earlier this year, it sued in its own name to try to prevent development that was taking place, developments of marina and housing that were taking place on its foreshore. The case has already been thrown out of court. Next slide. But what's interesting about it is it conveys to us this very important issue of the capacity of more than human or non-human entities to come before the courts to protect their rights. Next slide. Before we move to consider the various implications, it might be useful to get a sense of what people think nature is. So what is nature in your view? Is it everything on the planet that is not human? Is it land and other plant, animal, mineral resources? Or is it all physical matter in existence in the universe? I'd be really keen to see what your view is about this. What is nature?
That's quite a tricky one. We'll just leave that up there a few moments for everyone to answer. Yeah, I'm very intrigued to see what the answer to this one is. Okay, so we've got the answers now.
Okay, so terrific. So there's largely a majority of people thinking that it's all physical matter in existence in the universe, which would then of course include humans, but all other entities. A significant number regarding it as land and other plant, animal, mineral resources. So I would take that to be sort of excluding humans, although it could also, under the category of animal, include humans, and a small number who regard it as not human. So let's look at the various concepts and questions actually associated with thinking about nature as having legal personality. So the first thing is to understand that the notion of person comes from the ancient Greek term prosopon and its Latin variation persona. And in Greek and Latin, in ancient Greek and Latin, a persona was a mask. It was a facade that you placed in front of yourself, and you can adopt a variety of characters through this mask. And in a sense, that continues to this day. I'm sure many are aware that corporations have legal personality, and in a sense that is a facade that conveys a particular identity, albeit with other types of persons who sit within, outside, or beside that legal personality. And in relation to this legal personality, various rights and duties can be allocated. And what we're seeing in the context of climate change and mass extinctions and various ecological catastrophes is that the notion of personhood is being expanded. And what I'd like to really talk about is the implications, the social, economic, and political implications of the expansion of legal personhood. There's an important history to bear in mind when we think about the expansion of legal personhood, and often the literature refers to slavery because it was the granting of legal personhood to people, categories of people who were slaves, that was meant to free them. Now, there is some fiction, there is a kind of inconsistency within that as well, which is that it was also the case that people who were slaves could be a chattel, could be owned by another person, and that was the nature and character of slavery, but they could also be held responsible for homicide. So this notion of legal personality and how slavery is used as an example to animate, to explain what it means to not be a person is actually a rather more complicated affair. So that is often one of the reference points when people say, well, nature is being abused or a river is being abused. The the analogy is with the abuse of human persons during the period of slavery, for example. And the broader concern here is who should matter and what should inform discussions around issues of sustainability, climate change, and mass extinctions. So let's move to the next slide. Now, a very famous example now of legal personhood being granted to non-human entities is the case of the Wanganui River in New Zealand and the surrounding area and the hills and landscape associated with it. Next slide. If you'll see that in order to make the Wanganui River and the stretch of land around it a legal person, an act of parliament was necessary. The Te Ua Tapua Wanganui River Claims Settlement Act 2017 was the legal instrument that created this legal personhood. And there are custodians of the river that now act on its behalf. So the actual practicality of making a river or a mountain, other waterway, a legal person is a relatively straightforward mechanism that we're familiar with, which is an act of parliament. But what kind of entity can be a person, and what are the broader implications of this, is something that we need to think about. And I want to say a little bit about the history of that, even though obviously we see a very successful example in New Zealand of the Wanganui River being recognized as a legal person. Next slide. So that takes me to the key authority in relation to legal personhood in the US, and I want to connect this back to Lake Mary Jane in Florida, which I started with. And this is a very influential authority, Sierra Club versus Morton, the major Supreme Court case in 1972. And it involves a situation when the Disney Corporation wanted to build a very large ski resort in the Sequoia National Park. And as some of you will be aware, the Sequoia National Park has some of the oldest trees growing in that region of the world. The Sierra Club was a group of nature enthusiasts, mostly walkers, who wanted to put a stop to the development. And they confronted the issue of how they could intervene to stop the development. And on this slide, I set out the legal framework that they were confronting in bringing an application to the court. And the key thing was that it was required that a person suffering a legal wrong bring the case. Now, if the Sequoia National Park is the entity or phenomenon suffering the wrong, you see that there is already a legal limitation. And what the Sierra Club were claiming was that they had a particular aesthetic interest or interest in the ecology that would be affected by the proposed development. Next slide. Justice Stewart gave the leading judgment, or the majority judgment in the case, and Sierra Club were refused standing. It was recognized that there could in fact be a harm or an injury, but in order so that Sierra Club's interests of walking and so forth could be affected, but they were very narrow in their definition of what an injury in fact requires. And it was stated that it requires that a party seeking review be himself among the injured. So if the Sequoia National Park was to be injured, then it was the Sequoia National Park that would have to come before the courts, and that was not permitted by the Supreme Court. If we move to the next slide. Importantly, there was a very lengthy and strongly argued dissent by Justice Douglas, who claimed that all inanimate objects, the woodpecker, the coyote, the bear, as well as trees and landscapes, ought to be able to come before the courts. And groups who value these wonders could represent the interests of these non-human entities. This was not the position that prevailed, but it was an important dissent. Unfortunately, given the composition of the current US Supreme Court, I'm not expecting that this legal authority is going to change anytime soon. But what it has done is inform the position taken by legal activists and many discussions about the allocation of legal personality to non-human entities, animals, trees, rivers, and so on. Next slide, please. The intellectual background to the position taken by Justice Douglas was influenced by a very important article, academic law review article written by Christopher Stone called "Should Trees Have Standing?" And I refer you to that book, which is the article which was then expanded into a book which is available. And he makes again many comparisons in his argument with slavery. He compares the condition of what we call nature today, and we saw that there are different views, of course, about what nature is, that the instrumentalization, the exploitation, the extraction that is taking place relentlessly and increasingly, as we know, in relation to fossil fuels, for example, is compared to a condition of exploitation that existed during slavery. And at least in the liberal legal framework, it is the granting of personhood and rights that is seen as creating the conditions for a shift from that position. I'll move through the next couple of slides more quickly for reasons of time, but it just expands the argument that Justice Douglas put forward to establish that non-human entities should have legal standing. And if we can move to the slide on Sellafield in Cumbria, please. So this is the main case, the Greenpeace case, that is the authority in the UK in relation to what's called representative standing. That is to say, a group that has an interest in a phenomenon, in a development, in this case, the emission of radioactive waste from the Sellafield nuclear plant in Cumbria. Now, Greenpeace as an organization didn't have an office next door to the nuclear plant in Sellafield. It was an international representative body. And if you just move to the next slide, you see that this case was brought in 1994, at a time when Greenpeace was yet to fully establish itself, or you could say cases like this helped Greenpeace to establish itself as a representative environmental body. Some of you will recall that it was only about 10 years previously that the flagship of Greenpeace was attacked and a bomb was set off by the French Secret Service in New Zealand, the bombing of the Rainbow Warrior. That was only, I think about 8 or 10 years before this case was brought. So Greenpeace was establishing itself as an authoritative group that could represent issues such as the emission of radioactive waste, and the so-called representative standing was established. Now, if you ask yourself, why did this take place? Well, courts are recognizing that organizations like Greenpeace have the resources, the expertise, the ability to gather chemists and physicists and so on to launch a competent action. So this idea of a competent litigant is very important for courts, because they don't want their time wasted by people who don't have the resources to properly mount the case. Now, the case was mounted, and of course Greenpeace didn't win the case. So one of the arguments I make in relation to cases like this, and it's a caution about the use of the law, is that what you can find in these cases is the rule of law itself being vindicated without necessarily an outcome of environmental justice. So the courts serve as a forum for social political issues to be contested without fundamentally changing the grounds, the definitions, the assumptions that underline our social and political organization. And arguably, the Sierra Club versus Morton case is another one of those kinds of cases. If we move now to the next slide, this is an example, more recent example from the Netherlands, the Agenta case, where the Dutch government faced a group of climate activists who wanted the Dutch government to adopt a reduction of greenhouse gas emissions at a higher level of reduction than the EU standard itself. I think the EU standard was about 17%, and the Agenda, which stands for Urgent Agenda, group wanted the Dutch government to adopt a 25% reduction, and they felt that that would be the more responsible position to adopt. And the Dutch, initially the Dutch District Court that heard the matter, but it was affirmed all the way to the Supreme Court of the Netherlands in 2020, upheld the Agenda claim. And the Netherlands was therefore required to reach for a higher level of reduction. And what's important about this case is that, firstly, that there was a judicial intervention in this in the first place, because of course it is the sort of case that has a lot of scientific information and data, and the fact that the courts are receiving these scientific information and data, the reports of the IPCC, the Intergovernmental Panel on Climate Change, the fact that the usual judicial deference to what should be the province of government and what should be the province of courts is shifting, as well as the obligation to future generations that was recognized in this case. All of these elements are very important, and the Agenda case is likely to be a sort of test case referred to in future climate-related litigation around the world. So and the other dimension of this is that I mean, the proceedings are usually in Dutch, but the Agenda organization has funded and facilitated the full translation of all of the transcripts that are freely available online, and that is an important resource, therefore, for groups who are engaged in climate-related litigation. If we move to the next slide, another example of climate-related litigation in Europe. This case is still underway, a Klima Signorinen case, which involves litigation brought by Swiss women over 75. So you said that's a particular category of people who are arguing that they have a heightened vulnerability to pollution, to the impacts of climate change, rising temperatures, and so on. And they're using European Convention for Human Rights protections, Article 2, the right to life, Article 8, the right to private and family life, which is often used in these cases, to argue that Switzerland as a state has a obligation towards them, and that they're breaching their human rights in not taking greater steps to tackle climate change. And this particular case has been referred to what's called the Grand Chamber of the European Court of Human Rights. 17 judges will give judgment in this, and the outcome of this is keenly awaited. So an example of how human rights are being used in the courts. If we move to the next slide, and I'm conscious of the time, I'll be bringing this presentation to an end shortly. I wanted to refer you to the draft definition of ecocide that has been created, sponsored by the Stop Ecocide Foundation, which is a charitable organization. And the expert panel included former International Criminal Court prosecutors, as well as QCs like Philip Sands, and experts in the area, who drafted a definition of ecocide that could potentially be adopted into what's called the Rome Statute, the statute of the International Criminal Court. So if you read the definition there, for the purposes of the statute, ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. If you click through on the Stop Ecocide Foundation link that is on this slide, each of these words has a definition. I haven't extracted all of them, but you see the term wanton, an interesting term to be used, applying a standard that is not as strict as, let's say, the Genocide Convention, where you have to demonstrate an intention to commit genocide, which is often a very difficult thing to prove. You know, people who commit genocide don't say they're going to eliminate a people expressly, and therefore genocide prosecutions and convictions are very hard to gain. But wanton here means reckless disregard for damage which would be clearly excessive in relation to the social and economic benefits anticipated. And so I think in the context of climate change being caused by the consumption lifestyles, the creation of certain kinds of products, the use of fossil fuels, and the acceleration in the extraction of fossil fuels, for instance, I think all of these categories are ones that could potentially come within this broad definition. Now, the definition hasn't been adopted by the ICC, and changing the ICC statute would, of course, be very difficult, because there will be many nation states and groups who would want to prevent its adoption. But one of the startling things, and I think I might leave you with this thought, that one of the drafters, when asked about it, said about the conditions under which it would be adopted. They said, well, there will come a time when there is such a catastrophic loss of life that they will want something, countries will want something that's on the shelf, ready and waiting to be adopted. And recall that the Genocide Convention is adopted after the Second World War, after the loss of many millions of lives, the Holocaust of European Jews, and the loss of other lives before it was adopted. But I think that tells you something about humanity, perhaps, that we are waiting for this catastrophic loss of life before we adopt the legal instruments that might, in fact, prevent it. So I'll leave you with that somewhat sober thought, but hopefully we'll be able to have a more hopeful conversation.
Yes, indeed. Thank you very much for that in-depth presentation, Professor. Do keep sending your questions in using the chat facility.
Charlotte, sorry to interrupt you. I did forget that I'd added a quiz to the end of this presentation. And I wonder whether we should actually do that quiz.
Yes, let's just do that one now before we move on to questions. So it should just be up on your screen now.
So it is, what does sustainability of current economic and social models mean? Does it mean sustain economic production and growth but offset the impact of this growth? Does it mean reduce production and growth to levels that sustain all life? Or does it mean only develop products that sustain ecosystems and life? So there is a lot of talk of sustainability, but what does that mean? Sustainability of what?
Just leave that up there for a few more moments for people to answer. Quite mixed views on that one.
Yes, mixed views, but interestingly, a significant majority only develop products that sustain ecosystems and life, and that's a very hopeful message, as well as reduce production and growth to levels that sustain all life is the one that comes second there. So I think that is a really interesting outcome here. Certainly suggesting that there might be, at least in this audience, appetites to rethink what growth and production mean. I think that's really important.
Great. Also, just what you were saying before on ecocide, one of our listeners, Leave, has said that in the upcoming new criminal code, a separate title is foreseen to be ecocide. So that's definitely something I'm sure we'll hear more about. And one of our audience members, Robert McDowell, has asked, are these legal concepts of endowing legal personality on non-humans essentially legal fictions created by the judiciary to achieve certain objectives?
That's a great question, and very important to use the word legal fictions, because legal personality is precisely that. It is a legal fiction. But of course, a legal fiction is nothing to be afraid of. You know, much of the concepts that we use are indeed what are called, and many 18th, 19th century philosophers did a lot of work on this. They're called consciously false assumptions and definitions and formations. So yes, they are legal fictions. It's not, of course, in their extension, it will be judges that are determining this. So, for example, when the corporation began to be treated as a legal person in the United States, it was through the Equal Rights Amendments that this took place. So that in itself was quite controversial, and in the late 19th century it was judges who declared this to be the case. So that extension is certainly a reading of existing constitutional provisions or legal protections that are then interpreted by judges. In India, for example, there are quite a number of decisions of the lower courts with, let's say, somewhat eccentric judges who are extremely committed to animal rights, who declare, elephants to be having the status of a legal person and legal protection. Now, of course, all of that exists within the context where a legislature could legislate on it, but we're yet to see, I think, extensive legislation in the area in many countries, in most countries.
Then, on that note, if non-humans are given certain rights, are there corresponding duties placed on the non-humans with legal personalities?
Yeah, another great question. Yes, so in the example of the Wanganui River, for example, there are duties that accompany the recognition of legal personality. And you know, I think those are things that the custodians of the non-human entity would have to carry out. I mean, there would be the responsibilities then of those who exercise agency and exercise custodianship for the entity. I mean, the thing about rights and duties, and that rights have corresponding duties, is also a particular framing of what it means to have rights. And I think it is something that usefully pushes us to think whether legal personality is the best way to go. I mean, I think that I would use this question to say that I'm not necessarily here advocating that the extension of legal personality is the answer. I'm if you like, charting the legal terrain, saying this is how we are tending to deal with the problem of climate change and ecological catastrophes, etc., because we're bringing the existing legal tools to it. But I think when we think about economic and social organization, we need to think beyond the available tools. We need to perhaps develop better concepts, newer concepts. So here we are extending a Roman law idea of legal personality, or coming up with another definition of a crime, rather than perhaps thinking, and hence my final quiz question about sustainability, thinking what should production mean? What is a sustainable level of growth? How do our products, financial or other products, how can they be consistent with the survival of all humans and non-human life? Just to give an example of this, there's a massive, as you probably know, massive expansion in copper mining, lithium mining, and the other minerals required to sustain the batteries for electric cars and other devices. So decarbonization can't mean, in my view, the replacement of the combustion engine with a lithium battery, a greener car, because there simply isn't enough copper to supply the new grids of electricity and lithium to sustain the batteries that would be necessary. And that, I think, means we have to ask ourselves a question about what's a sustainable mode of transport in a city, for example.
We've got quite a few more questions to get through. Going back to the legal precedent, Trevor Hilder has said that gods and goddesses in India have legal personhood, but they are legal minors who must be represented by legally responsible trustees. Is that not a good precedent for nature?
Yeah, a useful example, definitely, that is the case. And there is then the relationship of trust, and that the trustee has fiduciary duties to gods and as they do with gods and goddesses, that the trustee can have this fiduciary relationship. I think there's still a question of power involved there, particularly when it comes to the distribution of something like a resource. Let's say it's a river and it involves water. What happens upstream and downstream is going to matter to individuals who have a relationship to that river. So I think some of the things I was just mentioning are going to return to a trustee with a fiduciary duty for a river or for a territory, and this, of course, many indigenous communities around the world face this question because they either inhabit or have a claim on resource-rich land, and often what non-indigenous people and perhaps other indigenous people want to do with that quote resource or that land is one that creates contested claims. So I don't think these contested claims can be fully addressed by the legal structure of the trusteeship.
Okay, then Clive Bullen has asked, how much of the largest countries in the world, such as China, India and the USA, how much have they brought into legal protection for the environment?
Well, I mean, that's a very big question that I don't have all of the specifics on. I think it's different in all of these countries. I think there are movements, but I'm sure, as many of you know, it is highly contested at the moment. And one of the issues is that there is an acceleration of the both the issue and use of licenses for fossil fuel exploration. And one of the cynical I think realities of this is that many fossil fuel companies are putting themselves in a position where they will have to be compensated for decarbonization. So they're increasing investment in areas, I think, with a view to the fact that when economies are decarbonized, governments and ultimately the populations of these states will have to be in a position of compensating such companies. So that, I think, is a very significant issue that we face in the context of the financialization of these corporations.
Okay, we're running out of time, but one last question. It's quite hard to answer fast, but I'll get you to get in touch with Mark Keith after this. But his question is, can you see the ecocide definition impacting the production of electric vehicles because of the need for nickel that you mentioned? And if so, how should manufacturers transfer this risk or protect themselves for future litigation?
Yeah, that is a very difficult question to answer in a brief way. I think one of the useful things about, and the other thing to emphasize is, of course, that the ecocide definition has not been adopted yet. But I think it tells us something about the direction of travel. And I think there are the ecocide definition, and you can think about the tobacco example and what was known when in relation to the tobacco industry, and also what is known now about the impact of climate change, the use and extraction of the resources that are going along with decarbonization. I think it's going to be difficult to offset risk, and I think what I find some hope in actually is some of the answers that you've all given to the quiz questions, which is that production itself is going to have to be rethought, how we organize transport, travel, consumption. I might be hugely optimistic, but I think in 30 years' time, the full-scale consumption of meat and animal products, as we now know it, will be dramatically different. We're not going to stop eating meat, I don't think, but I think the cost of it will be something that we think intensely about, that we will be having many more discussions within families about the level of meat and animal product consumption given its impact on the environment.
Thank you very much. It's been fascinating to learn from you this afternoon, Professor. And once again, thanks to our wonderful sponsors for making these webinars possible. And equally important, thank you to you, our lovely audience, for your time and contributions today. And don't forget to check out our forthcoming events on our website. We've got more stimulating topics coming up this week, from the EU AI Act, State of Play tomorrow, to stablecoins, crypto's killer app on Wednesday. And if you're in London and work in fintech, why not come along to a fintech meetup in the city? All of these details are on our website. Thank you very much and take care.